You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Hi, hello everyone. Welcome to this Wiley Rhine webinar on hiring individuals from the government, post-employment and conflict of interest laws, regulations, and policies for the executive branch and Congress. I'm Rob Walker of counsel in Wiley's Election Law and Government Ethics Practice Group.
Hi, and I'm Sacilotto, and I'm a partner in the Government Contracts Group at Wiley.
I want to talk here about the topics we're going to cover. You'll see them here: communicating with federal government employees on prospective employment, post-employment restrictions, Section 1045 of the National Defense Authorization Act for fiscal year 2018, the Emoluments Clause, contractor unique provisions, the Biden Ethics Pledge, financial conflicts of interest, private sector employees entering the government, and service on federal executive branch advisory boards. A lot of ground to cover, but before we begin addressing specifics, I just want to start with an overall comment. Federal employees and officials clearly can be an important and, for some organizations and industries, an essential source of experience, expertise, and insight. Of course, there I'm speaking out of self-interest as a former employee of the executive branch and of both houses of Congress. But to maximize the upside to your organization in hiring people from the government, you want to make sure that you can navigate deliberately and carefully through the landscape of legal requirements and potential pitfalls posed by the hiring process and by having a former federal official on your team. This webinar provides, we hope, an overview of that landscape. So let's get into it. Let's talk first about restrictions relevant to communicating with federal government employees on prospective employment. These are restrictions that apply directly, for the most part, to the government employee. However, private sector persons or entities engaging in employment discussions with government employees should be aware of the requirements and should assure that the government employee with whom they are engaging is following the requirements. So first, you see here for the executive branch restrictions and requirements regarding seeking employment. An employee who is seeking employment or who has what's called an arrangement concerning prospective employment must recuse himself or herself from participating personally and substantially in any particular matter that has a direct and predictable effect on the financial interests of the prospective employer. There are some exceptions. There may be a waiver granted. There may be agency authorization, or an exception exists under certain circumstances where the communication by the employee of the government is limited to submission of an unsolicited resume. But let's unpack some of these specific and key terms here. Seeking employment by a government employee includes negotiation, but it's broader than just negotiations. As I said, it includes negotiations, which in this context means discussion or communication with another person or such person's agent, mutually conducted with a view toward reaching an agreement regarding possible employment with that person. This term is not limited to discussions of specific terms and conditions of employment. It's conditions of employment in a specific, for a specific position. The term negotiation is going to be one that we're going to see vary in the executive branch, between the executive branch and the Congress, and even within the Congress between the House and the Senate. So pay attention to what the term negotiation means where your particular potential employee is employed in the government. Making an unsolicited communication to any person regarding possible employment for the sole purpose of requesting a job application is also included here, as is making a response other than rejection to an unsolicited communication from any person or such person's agent regarding possible employment with that person. Seeking employment ends, you'll see here, when either party either rejects the possibility of employment and all discussions have ceased, or 2 months have passed since the employee sent an unsolicited resume or employment proposal, and the employee has received no indication of interest from the prospective employer. Rejection must be clear, and a response deferring discussions until a foreseeable future or any other similarly vague or open-ended response is not a rejection of an unsolicited overture regarding prospective employment. So let's unpack again some other key terms here. What is a particular matter as used in these regulations and statutes? A particular matter you'll see here includes only matters that involve deliberation, decision, or action that is focused on the interests of specific persons or discrete and identifiable classes of persons. It is not just limited to matters involving named or identifiable parties. On the other hand, the term is not so broad as to include consideration or adoption of broad policy options or alternatives directed to the interests of a large and diverse group of persons. Let's talk about certain notification and documentation requirements that arise in communicating with executive branch employees on prospective employment. The employee must take all necessary steps to assure that they have effectively recused from a matter or matters as required if they are negotiating or seeking employment with a private sector employer. Recusal may include oral or written notification of recusal. It could be to coworkers, supervisors. It certainly, in my view, should be to the agency ethics official and also to the supervisor. There are some instances where written notice of recusal is required. You'll see here that it may apply under the Stock Act, the Stop Trading on Congressional Knowledge Act of 2012, or it may written recusal may be required as evidence of compliance with an executive ethics agreement with the Office of Government Ethics, OGE, for example, for Senate confirmed positions. Some agencies may require written recusals, and coming up, we are going to look at some best practice measures on the part of prospective employers, perhaps your organization, for example, with respect to obtaining written recusal statements from persons from the government with whom you are negotiating for employment. Let's move to the Congress and talk about communicating with senators and staff on prospective employment. You'll see here, first of all, a general statement from the House Ethics Committee on the importance given to members and staff avoiding conflicts and the appearance of conflicts with prospective employers. What is the appearance of conflicts? Good question. You tell me. It's a very broad term, and so you want to give conflicts of interest a very wide berth in terms of what may be viewed as an appearance of a conflict with a senator or a Senate staffer. For senators, there are two provisions relating to communicating with potential private sector employers. The first is that senators may not negotiate or have any arrangement regarding prospective employment for a job involving lobbying until after his or her successor has been elected. More importantly, perhaps, for all other negotiations or arrangements with senators regarding prospective employment, the senator must first file a signed public statement with the Secretary of the Senate within 3 business days after the commencement of job negotiations or an arrangement for future employment, and the senator must recuse from any matter, official matter, or action if there is a conflict of interest or appearance of a conflict with the prospective employer with respect to the prospective employer, and the senator must notify the Senate Ethics Committee in writing of such a recusal. For officers of the Senate, such as the Sergeant at Arms or the Secretary of the Senate, and for senior staff, that is, staff paid at a rate that you see here, for at least for calendar year 2022 of $130,500 or more, the requirements are that they must notify the Senate Ethics Committee in writing within 3 business days after the start of negotiations or arrangements for private employment. And as part of that notification, they must certify that they have recused from any contact or communication with a prospective employer on issues of legislative interest to the employer and on any official matter posing a conflict or the appearance of a conflict for that employee with that prospective employer. These are not publicly filed statements as opposed to the statements for the senator, which will be publicly filed. So I mentioned before how the term negotiation can vary and does vary across various sectors of the government. In the Senate, the term negotiation as used in this prospective employment context is very narrowly defined. It's, so to speak, a very late stage in the process definition. In the Senate, it means the discussion of terms and conditions of employment after an offer has been made and the member officer or employee is considering accepting that offer. An employment arrangement in the Senate begins when an offer has been made and accepted. But keep in mind, and we will see, the very different definition of terms for the U.S. House, which we now are getting to. So the House Ethics Committee, like the Senate Ethics Committee, also provides a very broad statement applicable to negotiations for future employment. The House Ethics Committee cautions that members, officers, and all House employees should be particularly careful in negotiating for future employment, especially when negotiating with anyone who could be substantially affected by the performance of the employee's official duties. So, what are the requirements for members negotiating with potential private sector employers or coming to a possible employment arrangement with such private sector employers? Within 3 business days after the start of any negotiation or agreement for future employment, a member of the House must file with the Committee on Ethics a signed statement including the name of the private sector entity or entities involved in such negotiations or agreement and the date the negotiations or agreement commenced. You'll see this differs a little bit from the Senate requirement, where the notice, this portion of the notice, is already publicly filed. For the House, this can just be filed with the Committee on Ethics. However, the member must also recuse himself or herself from any matter in which there is a conflict or an appearance of a conflict, must notify the Committee on Ethics in writing of such a recusal, and upon such recusal, must submit to the Clerk of the House for public disclosure the statement of disclosure regarding the related employment negotiations or agreements. How about for officers such as the Chief Administrative Officer or the Clerk of the House and certain House staff? And the House staff here we're talking about, again, are staff who, for the calendar year 2022, are paid at the rate of $130,500 or more. That rate has held steady for the last few years, but it's paid to a member's salary. So when members eventually do decide to increase their salary, this rate will change for House employees as it will for Senate employees. Anyway, officers and these highly paid staff must notify the Committee on Ethics in writing within 3 business days after the start of negotiations or an agreement for private employment. and must recuse from any matter in which there is a conflict or appearance of a conflict, and notify the Ethics Committee in writing of such a recusal. So, what about the meaning of the term and the scope of the term negotiation in the House of Representatives? Here, it's construed broadly. It includes situations where there is, quote, communication between two parties with a view toward reaching an agreement and in which there is active interest on both sides. You don't get as far along in the process in the House as you do in the Senate before communications are deemed to be negotiations requiring notice and potential recusal. However, the House Ethics Committee makes clear that merely sending a copy of one's resume to a private entity is not considered negotiating for House purposes. All right, let's talk about just a few practice pointers, and they may seem self-evident to you in connection with communicating with federal government employees on prospective employment. As soon as possible, upon the start of any communications with a government official or employee regarding prospective employment, your organization should confirm with that official or employee that they have notified in writing their ethics office of their prospective employment communications and negotiations and of their actions regarding recusals. Also confirm that any notices or statements required to be filed publicly have been filed. You should obtain, review, and maintain copies of all written notifications and statements, whether public or confidential. Now, there may be some portions of these communications between a government employee and his or her ethics office that may be government confidential and may have to be redacted, but you still want to get copies of those communications whenever possible. As a best practice, the House Ethics Committee, for example, advises House personnel communicating with potential private sector employers. They advise the establishment of an exchange of correspondence with the negotiating partner, stipulating first that the negotiating partner will receive no official favors as a result of the job negotiations. And that should be true not just in word, but in fact. And if relevant, the exchange should also note that the member, officer, or employee is subject to post-employment restrictions, which should be briefly outlined in the exchange. And your organization should obtain and review copies of all post-employment guidance to candidates from the employing agency ethics office. Obviously, post-employment guidance will not be available yet during the employment negotiation process. But you should be aware of what the potential post-employment restrictions will be and should obtain a copy of the agency's post-government employment guidance letter or memo to the employee as soon as possible when available. If a prospective employee says their agency does not provide such written guidance, you should push back gently but firmly if you must. You want a full and papered record regarding any hiring decision you make involving people from the federal government. Okay, new territory. Let's start talking about post-employment restrictions. We'll start here with the U.S. Senate. And you see here a list of the relevant restrictions. For 2 years after leaving office, a senator may not communicate with the intent to influence any official action with any member, officer, or employee of either House of Congress, of the House or Senate. This is for 2 years. That's pursuant to federal statute. For 1 year, they may not represent, we're talking about senators here, may not represent a foreign government or foreign political party before a federal official, and may not, even behind the scenes, aid or advise any such foreign entity with intent to influence a federal official. This is pursuant to Title 18 of U.S. Code Section 207F. We're going to come back to this in a lot of other contexts, and so I'm going to refer to this shorthand by 207F, foreign entity restrictions, as I go forward. Also for senators for 1 year, They may not use confidential information obtained during participation in trade or treaty negotiations, in representing or aiding or advising anyone in the private sector with respect to such negotiations. Again, this includes a behind-the-scenes prohibition. This is 18 U.S.C. 207B, which I will also refer to as trade or treaty negotiation restrictions in slides further along in this process. Violations of Title 18, Section 207 may be punished as felonies. So this is territory to tread very carefully and deliberately in. There are some exceptions. We're not going to go over them here. They are set out in Section 207J of Title 18. In addition, under Senate rule, senators are subject to restrictions on becoming a registered lobbyist under Senate Rule 37. And also, under Title 18 U.S. Code Section 203, which we will refer to as we go forward in other contexts, senators may not share in profits earned by a private sector employer from representing clients before any federal department, agency, or court at a time when the senator was in office. And for senators who are attorneys, keep in mind that relevant bar rules may also apply. These include rules relating to successive government and private employment, for example, DC Bar Rule 1.11, but it also includes the general rules relating to former client conflicts, such as DC Rule of Professional Conduct 1.9. All right, let's talk here about some of the important terms and the application of certain concepts for Title 18, Section 207. These are going to apply throughout as we go forward, both in the congressional context and in the executive branch context. So it's important here to focus on these. Communication and appearance. Both of these terms should be construed broadly. Communication is any type of communication, no matter how it's made, in person, telephone, email, whatever, with another person with the intent to attribute the communication to the former employee. A former employee who just attends a meeting and sits quietly with others who may attempt to influence, they are also there appearing in a way that is problematic under the statute. So they should not engage in such activity. Action and official action, what does that mean? So obviously we're all aware that post the McDonald versus U.S. Supreme Court decision, the scope of official action has seen some narrowing, but in practice, you don't want to come close to the line here. So to avoid risk, these terms should be read to include all actions and decisions made by an official, as even simply scheduling a meeting. Under 18 U.S.C. Section 207, behind-the-scenes advising is generally permitted, except, remember, for the 207B provisions relating to trade or treaty negotiations, and for the 207F provisions relating to restrictions communicating or appearing or advising or representing foreign entities, governments, and political parties. Finally, under Section 207, social contacts are permitted. Purely social, non-business communications with current government employees are permitted. Senate staff, certain highly paid Senate staff are subject to restrictions. You'll see them here. Basically, the most important one is the one-year restriction on going back to anybody in the entire Senate with respect to any matter on which they are seeking to influence official action. Senate Rule 37 does also apply with respect to restrictions on lobbying. Also, the one-year restriction on representing or advising foreign entities applies to highly paid staff. For all Senate staff, the one-year provision relating to trade or treaty negotiations applies, and as does the restriction on receipt of compensation under 203, 18 U.S.C. 203. For members of the House, They have a 1-year restriction on going back to any member, officer, or employee of either House of Congress or any other legislative office. They are also subject to 207F relating to foreign entities, 207B relating to participation in trade or treaty negotiations, and 203 regarding receipt of compensation for representations before the federal government. Bar rules also apply if they are attorneys, and of course, the bar rules also apply to Senate staff who are attorneys. For House staff, for 1 year after House employment, if they are, again, highly paid staff at the rate you see here, they are subject to more focused restrictions than are highly paid senior staff. They are basically employing office specific restrictions. They may not go back to their covered former personal office or their covered former committee office or the members or staff thereof for 1 year after they leave. Leadership staff, it's a somewhat broader restriction. They may not go back or seek official action from current members of the leadership or current staff of those members for 1 year if they are at this highly paid level. These highly paid staff are also subject to the 207F restrictions on representing, aiding, or advising foreign entities, also the 203 restrictions on receipt of compensation, and the restrictions on trade or treaty negotiations, and bar rules if they are attorneys. Okay, we have finally gotten to the executive branch. Let's talk here about some important restrictions. For the executive branch, employees, there is a permanent ban on making with the intent to influence any communication with or appearance before the U.S. government on behalf of a private party in any particular matter involving a specific party or parties. That's an important term of art, in which the former employee participated personally and substantially as a government employee. That's a felony, potential felony statute there, as is a 2-year ban on making with the intent to influence any communication with or appearance before the U.S. government on behalf of a private party in any particular matter involving a specific party or parties on which and in which the former official or employee knew or reasonably should have known, in which they knew or reasonably should have known was actually pending before their official responsibility during the last year of government service. We're going to unpack some of those terms. 207B on trade or treaty negotiations, 203 on receipt of compensation, and bar rules will also apply. Okay, what's a particular matter involving a specific party? It covers any specific proceeding affecting the legal rights of parties or an isolatable transaction or related set of transactions between identified parties. Examples: contracts, grants, licenses, product approval applications, investigations, or litigation. The term doesn't cover so-called particular matters of general applicability, such as generally rulemaking, legislation, or policy making of general applicability. However, particularly with respect to rulemaking, if that is focused more narrowly on the interests of specific parties rather than on an industry or profession or other class of persons or entities, such a matter could be considered a particular matter involving specific parties. What does participate personally substantially mean? You see here the definitions. And it's important to focus on the definitions when you are considering the restrictions applicable to someone who you may be hiring from the government. I'm not going to read through them here, but important to keep these in mind. There are additional statutory restrictions for former senior employees of the executive branch, and specifically those who are paid at a rate equal to or greater than a particular rate set out here relative to the executive schedule. For calendar year 2022, that rate that kicks this restriction in is $176,201. This is the 1-year ban restriction under Section 207C of Title 18. It's a ban on making with the intent to influence any official action or any communication with or appearance before any government department or agency in which the former official served during his or her last year in government service. Keep in mind, it may be more than one agency or office for a government employee, and it also may apply either department-wide for some departments. Many departments, however, are broken up for purposes of application of this statute into components, where it's focused specifically on the component of that agency from which the former employee came. And the restriction on the kind of revolving door restriction and cooling off period applies only to that component. There is also applicable to these senior employees, the 207F foreign entity restrictions also apply. There are additional restrictions for former very senior employees. You'll see who they are here set out, and this includes a 2-year ban, similar to the 1-year ban we just talked about, but focusing on the department or agency in which this person served during their 2 last years in government service. But it also applies to any individual going back with the attempt to influence any individual appointed to an executive schedule position. And then there is also the 1-year provision under 207F applicable here. Agencies do provide and will provide to current or former employees who have questions about the post-employment restrictions or the implementing regulations. They will provide guidance to that employee. The ethics office will provide such guidance. This is a very, very important resource in the process, not just for people leaving the government, but for potential employers, prospective employers of individuals leaving the government. So knowing that the agency will provide such guidance is important. Some agencies provide very thorough written guidance. Some may provide less thorough guidance, more of a template guidance. But from your perspective as a potential employer, you want to get as much specific written guidance as you can. Okay, let's talk about some kind of specialized concerns here, particularly here under Section 1045 of the National Defense Authorization Act. There is a 2-year ban on military officers in grades 09 and 010 and their very senior civilian equivalents on engaging in lobbying contacts with covered executive branch officials in the Department of Defense and on engaging in lobbying contacts and other lobbying activities, which includes behind-the-scenes activities with covered executive branch officials outside of the Department of Defense pertaining to a matter with respect to the DoD. There is a similar but 1-year ban applicable to military officers in grades 07 and 08 and their senior civilian equivalents. Lobbying activities, as I said, where it applies, the ban where it applies, includes behind-the-scenes aiding or advising, not just direct lobbying contacts with officials. Covered executive branch officials, as used here in this restriction, includes or is given the meaning that it's given under the Lobbying Disclosure Act. Here you see what the meaning of, on this slide, the meaning of senior civilian equivalent and the meaning of very senior civilian equivalent. Also some information on lobbying and lobbying contacts. Exceptions to communications prohibited by Section 1045. All exceptions under Title 18-207 apply, as well as under the Lobbying Disclosure Act. Let's talk briefly about the emoluments clause. This is important to keep in mind if you are hiring retired regular military officers, retired regular military personnel, or reservists. Under the emoluments clause, persons covered, that is, persons who hold offices of profit or trust, are prohibited from having any position in or receiving any payment from a foreign government except with the consent of Congress. This does apply in certain circumstances here and does come up sometimes with particularly when a program of a U.S. entity may be funded by a foreign government. You do have to be aware of these restrictions when you are hiring military or retired military personnel. Let's talk now about certain provisions under Executive Order 13989 that apply to political appointees in the Biden administration pursuant to an ethics pledge promulgated by that executive order. There have been ethics pledges over the past few administrations. Some of the provisions of this pledge are similar to past pledge provisions, but the Biden pledge does go a little further in certain significant ways. First of all, who are the political appointees to whom the ethics pledge provisions apply? According to the pledge, it's all full-time, non-career presidential or vice presidential appointees, non-career appointees in the senior executive service or other senior executive service type system. The key there being non-career appointees and appointees in positions that have been accepted from the competitive service by reason of being a confidential or policy-making character. Schedule C and other positions that are accepted. The definition of political appointee does not include any person appointed as a member of the senior foreign service or solely as a uniformed service commissioned officer. What are the revolving door provisions of the ethics pledge? Well, there are some that apply to people going into the administration and some provisions applying to people coming out of the administration. And in both directions, there are provisions that apply to all appointees and some additional provisions that apply to lobbyists. Let's talk about the revolving door provisions for folks going into the administration. First of all, for 2 years from the date of appointment, such an appointee may not participate in any particular matter involving specific parties, we've seen that term before, directly and substantially related to their former employer or former clients, including regulations and contracts. Now, I said we've seen that term, particular matter involving specific parties before. Yes, we have, but as used here, the term also includes any meeting or other communication that the appointee may have with a former employer or client relating to that appointee's official duties, any meeting, unless that communication or meeting relates to a so-called particular matter of general applicability. Again, those are matters focusing on the interests of a class of persons as opposed to individual parties. It relates to such a general matter of general applicability, and participation in the matter, in the meeting or communication, is open to all interested parties. Now, that might seem like a burdensome requirement, open to all interested parties. However, as that phrase has been interpreted and applied by the Office of Government Ethics, open to all interested parties means that 5 or more stakeholders will be in attendance. So that is not a particularly difficult barrier to navigate. But keep those requirements in mind. For lobbyist appointees, in addition, for 2 years after entering the administration, they may not participate in any particular matter they lobbied on within 2 years before their appointment. They may not participate in the specific issue area in which such a particular matter falls, and they may not seek or accept employment with an agency they lobbied within 2 years of their appointment. Specific issue area, as used here, by the way, means a particular matter of general applicability. You know, I've been throwing those terms around, and they are difficult terms to remember. and to understand the definition of. This may be a good time to give a shout out to the Office of Government Ethics and the materials that they have available on their website. There is a very useful advisory memorandum from October 4th, 2006, DO-06-029. This is perhaps the favorite OGE advisory for ethics nerds. It defines and it talks about particular matters involving specific parties, particular matters, and matter. It's great. You want to refer to that if you need to.
I think the OGE website is great. I often find, it actually has useful information. I also like their rules. I like how they're written in plain English. So yes, it's definitely a website to become familiar with.
So under the Ethics Pledge, I will say that waivers of any provision of the pledge are available. Now, there should be disfavored options. I don't know whether this next statistic supports that view or doesn't. To date, there have been 22 waivers of provisions of the Ethics Pledge for the Biden administration across all agencies, departments, and offices. Those waivers are all publicly available. Let's talk about the golden parachute ban. That's what it's called in the pledge. It's not just my shorthand for it. So all appointees are subject to it. They must pledge that they have not accepted and will not accept any salary, cash, or non-cash benefit from a former employer, the eligibility for which and payment of which is limited to individuals accepting a position in the U.S. government. No special bennies, cash or otherwise, for people just because they're entering the government. This provision operates in addition to a statutory and regulatory restriction applicable to all incoming government employees. These we're going to talk about briefly later. They apply to receiving supplementation of government salary or receiving an extraordinary payment from a former private sector employer. Let's talk about the revolving door on leaving the government under the Ethics Pledge. All appointees covered by the one-year restriction under 18 U.S.C. 207C that we talked about, it may seem to you like ages ago, they must agree that they will abide by that one-year revolving door provision prohibiting them from going back to influence their former agency. They must agree to abide by that for 2 years. And it also includes a restriction on communicating with senior White House staff, so it broadens the 207C restriction. Also, employees covered by 18 U.S.C. 207C and 207D, that is senior and very senior appointees by salary, agree they will not, for 1 year after their appointment ends, provide or hold themselves out as being able to provide behind-the-scenes support for others in making communications appearances the former appointee may not make directly. This is a so-called shadow lobbying ban. So it gets to those folks who leave the government, and while they may not trigger the registration and reporting requirements of the Lobbying Disclosure Act, hold themselves out as being able to advise on lobbying strategies and efforts. This provision of the pledge is different from past pledges, as is the golden parachute ban, and so this is a significant provision in the pledge. The only real question is, will this apply after the Biden administration? Because every administration previously, when it has ended, has basically said the pledge is no longer in effect. They revoked the pledge. So we'll see whether this is going to have any lasting staying power. Let's talk about appointees leaving the government to lobby. They must agree not to lobby any covered executive branch official as defined by the Lobbying Disclosure Act or non-career senior executive service appointee, or engage in activity on behalf of any foreign government or foreign political party that would require registration under the Foreign Agents Registration Act. This applies for the remainder of the administration or for 2 years after the appointee's appointment ends, whichever comes later. Let's talk here about some very important basic conflict of interest provisions applicable to all persons who leave the private sector and enter the government. Again, these are important for private sector employers to know about because these provisions can limit involvement by an executive branch employee on matters affecting their former employer, and they can apply criminal penalties if a government employee does not abide by these requirements and restrictions with respect to matters involving their former employers or involving their financial interests. So these are important in this in the landscape that we have been taking a broad overview of. Under Title 18 U.S. Code Section 208, also a criminal provision, these employees are prohibited from participating personally and substantially in an official capacity in any particular matter that would have a direct and predictable effect on that employee's own financial interests or on the financial interests of a spouse, minor, child, and certain others. The financial interests could include securities that they hold in whatever vehicle, through whatever vehicle or in whatever way, securities of their former employer. So it's important to keep this in mind. The remedy may include disqualification or recusal, that is recusal, or divestiture of the conflicting financial interests. A related statute going to impartiality requires employees to consider whether their impartiality would be questioned if their involvement in a particular matter involving specific parties, again, a term we've seen, might affect certain personal or business relationships, including with their former employer or clients if they were employed by them in the last year. Here are two provisions I referenced very briefly. One is Title 18 U.S. Code Section 209, prohibiting private supplementation of government salary. You can't, your former employer or anybody can't provide someone entering the government with a payment to supplement their government salary. Now, the key to avoiding 209 concerns is if the severance payment is made and completed before government service begins. There is also a regulatory provision requiring an employee to disqualify himself or herself in matters that involve, from matters involving a former employer that provided an extraordinary payment. You see what that means here. Finally, let's talk about service on federal executive branch advisory boards very quickly. Key question, is the person from your organization who is being asked to serve on such a body, whether it's an advisory committee or some other board, are they going to serve as a special government employee, SGE, or representative? If they're an SGE, they're going to be subject to certain ethics provisions and restrictions, including 208 on financial conflicts, 203 on receipt of compensation, 205 on representation before the government. Some of these have more limited applicability for SGEs serving 60 days or less in a calendar year. They are subject to prohibitions on outside payments, teaching, writing, speaking related to official duties, to fundraising, and to misuse of position, and to the receipt of gifts. They will also be subject to the post-employment restrictions under 207C, the one-year ban, if they are serving 60 days or more in the calendar year, and they will be subject to the permanent ban and the 2-year ban that we talked about earlier. Financial disclosure will be required of folks serving as special government employees or SGEs. A public disclosure will be required if they are serving more than 60 days in the calendar year. Finally, if someone is but someone in your organization is going to serve as an SGE or even as a representative on a federal advisory committee or other federal advisory board, you're going to want to consider organizational conflict of interest issues. I think we're still going, and I'm just going to here ask Cara to comment on the OCE issues in this context. I think you referenced them already, Cara,
yeah.
But they are something to watch out for.
Right, so it's conceivable, although I can't say that I can point to a situation where it arose, but it's conceivable that one of these SGEs or representatives could get some kind of non-public competitive information. Probably less likely that they would get proprietary information, but maybe some kind of acquisition related information. So, it's just, you always want to be cognizant of a potential OCI when somebody has been or is working for the government and then comes out.
It's been our pleasure to talk to you about hiring individuals from the federal government for this last hour plus. Thanks again. Thank you, Cara.
Thanks, Rob.
And talk to you all later.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.